The governor's nomination for Chief Justice of the Supreme Court, the Honorable Raheem Mullins. Justice Mullins, good morning. If you could raise your right hand for me. Do you solemnly swear or affirm the information provided to this committee will be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury? Great. Have a seat, and whenever you're ready, we'll take a short opening statement. I think you have to hit that microphone in front of you. There you go.
Good morning, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and distinguished members of the Judiciary Committee. I'm honored to have this opportunity to appear before you today. I want to thank Governor Lamont, who has nominated me for the position of Chief Justice of the Connecticut Supreme Court. I must also thank former Governor Daniel Malloy, who nominated me to serve as a Superior Court judge, then as an Appellate Court judge, and finally as a Supreme Court justice. I'm grateful for both Governor Lamont's and Governor Malloy's confidence in me. After starting my life in a public housing project in Middletown, I never would have imagined I could be nominated to be Chief Justice of the Connecticut Supreme Court. I credit my parents, Tim and Diane, who are both here today, with setting in motion the trajectory that brings me before you. I'm also grateful to my two sisters, Tashima and Akila. Of course, I'm deeply thankful for my wonderful wife, Nichelle, my three children, Tatiana, Nia, and Raheem Jr., and my two grandchildren, Aaliyah and Coyote. Without their love and support, I would not be here today. I attended public schools in Middletown and Cromwell until high school. I first attended Xavier High School in Middletown and then transferred to Watkinson Prep School here in Hartford for my senior year. At age 17, while still a senior in high school, I also became a father with the birth of my eldest daughter, Tatiana. My own father made me get two jobs in order to support her. Both my parents kept me on track, and without my knowing it, they instilled in me purpose, patience, a strong work ethic, and perseverance. In time, I became the first in my family to attend college and then law school. After law school, I had the privilege of clerking for the Honorable Frederick L. Brown on the Massachusetts Appeals Court. After that clerkship, I returned home. I first worked as an assistant attorney general in the Child Protection Division, where I represented DCF as a trial attorney, and after that, I argued criminal appeals before the Supreme and Appellate Courts as an assistant state's attorney. In 2012, I became a Superior Court judge. I loved being on the front line where I heard criminal, civil, and habeas matters first in New Haven and then in Rockville. That experience allowed me to appreciate firsthand how our Superior Court judges, the clerks, and the staff are the backbone of our judiciary. In 2014, I was appointed to the Appellate Court. I worked hard to write opinions that clearly and correctly applied the law to the issues under consideration, and I'm grateful to the colleagues with whom I worked, each of whom were scholarly and an absolute joy to work with, as were my law clerks and the tremendous staff at the Appellate Court. In 2017, I was sworn in as an Associate Justice of the Connecticut Supreme Court. Serving on the Supreme Court has truly been the job of a lifetime. Not only are the cases profound and interesting, but I also work with colleagues who are thoughtful, conscientious, and dedicated individuals striving to do the right thing every day. Being on the Supreme Court has allowed me to see our judicial system from all different angles, top to bottom. Off-the-bench activities have contributed to my experience as well. For example, since 2018, I have been the chairperson of the Connecticut Code of Evidence Oversight Committee. I've also had the honor of serving as a faculty member of the Judicial Branch's Civics Academy, where I, along with a practicing attorney, go into elementary school classrooms to teach a civic lesson so that students better understand their role in a democracy. I've also coached girls' youth soccer for the past 6 years. All these experiences, but especially my real-life daily experience as a Superior Court judge, an Appellate Court judge, and a Supreme Court justice, should serve me well as Chief Justice should I be fortunate enough to be confirmed. These experiences have also brought into sharp focus my vision to achieve the mission of the branch, which is to serve the interests of justice and the public by resolving the matters before it in a fair, timely, efficient, and open manner. My vision for the judicial branch is this: to leverage technology so that we can enhance access, efficiency, and transparency, with the ultimate goal being to better serve our citizens. So I would like to turn now to the projects I plan on instituting or enhancing. When the judicial branch developed its civil e-filing system 22 years ago, it was cutting-edge technology. However, the system is now in need of a drastic revamp. Also, the files for criminal and juvenile matters regrettably remain 100% paper-based. Getting our criminal and juvenile matters to be 100% paperless will be a top priority of mine. This goal will no doubt require a significant upgrade of our underlying technological infrastructure. However, we must, one way or another, bring the judicial branch fully into the 21st century. As we move toward fully electronic files, we must also be sensitive to the needs of self-represented parties and those individuals with few to no resources. I am adamant that no one seeking access to justice will be left behind. In addition, we must continue to focus on ways to do certain types of hearings remotely if such a platform is appropriate. Specifically, I'm interested in enhancing two programs: the judicial branch's online traffic ticket review program and its online dispute resolution program. These programs allow hearings on driver's license infractions and small claims matters to be conducted remotely, making the court process more accessible and more efficient. I also want to expand and enhance the judicial branch's video remote interpreting program. The need for interpreters is rising, and this program more effectively meets that need by enabling an interpreter to assist in a case in Stamford at 10 a.m. and then Tallinn at 10:30 a.m. We must also get Wi-Fi in our courthouses. In this technology-driven world of ours, it is unacceptable to me that the Torrington Courthouse is the only courthouse in the state of Connecticut that has Wi-Fi. The lack of Wi-Fi is a recurring complaint from the public and is exactly the type of experience that negatively impacts the public's perception of the courts. I fully recognize that significant resources will be required to achieve this goal, to upgrade the judicial branch's network, but now is the time to start bringing the wireless world into our facilities. Consistent with that goal, we must upgrade the judicial branch website. If I'm confirmed, I will ask the judicial branch's web board to develop a modernization plan for the website. Our website is a key way of communicating and interacting with the public, and in today's digital world, a modern, user-friendly website that is navigable from a smartphone is imperative. Fewer people are sitting behind desktop computers, and more business is being conducted from an iPhone or, even if you're like me, from an Android device. If there's a crown jewel among my goals regarding technology, it would be the transformation of our current courtrooms into state-of-the-art digital courtrooms. For trials, each juror would have their own tablet or iPad where lawyers can upload evidence, making the experience smoother and more efficient. The digital courtroom will lead to improved efficiency, thereby reducing delays associated with some of the physical logistics that waste time during trial proceedings. The development of digital courtrooms leads me to a longer-term vision. We must examine the infrastructure of some of the branch's facilities and determine whether it will be more feasible to repair them with the necessary upgrades or consolidate some and build newer facilities with all the capabilities befitting a 21st century courthouse. It is important that I make clear I look forward to working with the legislature to achieve many of these goals. I also intend to keep the lines of communication open and collaborate with members of the bar, soliciting their perspective. I also want to listen to the public so that the judicial branch can provide the best service possible. I recognize I've spent a good amount of time concentrating on technology, and I'm a true believer regarding its potential. Yet I would be remiss if I omitted this one vitally important observation. Technology will never take the place of a real person on the other end of the line, a clerk helping a distraught person at the window, or the judicial marshals keeping our courthouses safe. At our core, we are a public-facing institution, and we must remember that we are dealing with real people with real problems and often on one of the worst days of their lives. Granted, technology will give us a big lift, but at the end of the day, respect for the people the confidence and trust in our court system is predicated on our respect for the people we serve, and particularly our respect of their time and their expectations of us. In conclusion, I'm often asked, why do I want this position? And if I were fortunate enough to be confirmed, how will I remain grounded? I'm seeking this position because ever since my introduction to appellate law with my clerkship, I have wanted to be a voice in the room where change is made. I've wanted to help shape our laws to make positive change in our system and our world. As a Supreme Court Justice, I do have a seat at the table to do that. As the Chief Justice, I would be able to continue to do that, but also have the ability to make positive changes in the administration of our system. As to how I will remain grounded, for me, the answer is simple. I am acutely aware of the fact that many people before me have given everything, some including their lives, for a person like me to have opportunities like this. There was a time in the not too distant past where a person like me had no legal rights in some of the very courtrooms I have sat in as a presiding judge. I honor their legacy and sacrifice every day by remembering that they gave so much for people like me to be sitting in a chair like this today. Those thoughts keep me in check day after day. I want to thank you for the opportunity to address you, and I'm happy to answer any questions you have.
Senator Kissel.
Thank you very much, Chairman Staffstrom. Justice Mullins, congratulations. I think an awful lot of credit also goes to Governor Lamont for appointing you, and I think we're all better off for it. And at the outset, I want to say thank you very much for meeting with me a couple of weeks ago. I know that you and your office extended an invitation to all of us to meet with you personally, and I availed myself of that offer, and we had I think I did probably 99% of the talking, and that'll be my once and only time where you sit there and listen for an hour, because that'll never happen in the future. But thank you for listening to my issues and concerns. First of all, I think a lot of folks that may be watching or in the room don't understand that as Chief Justice, you're like the governor, but of the judicial branch, so that you are in charge. And it's more than just perhaps what we see on the national level where the Chief Justice decides who's going to write certain decisions, that you are going to have the authority to start and implement a lot of the changes that you just put forward, which I find extremely exciting. So my first question is, what are the levers of power that you actually have, assuming, and I have no doubts in my mind whatsoever, that you will be confirmed today and assume the role of Chief Justice, and then I believe that you'll come back for when the full session goes into, when we all come back, whoever gets elected or reelected in January. And I'm just wondering, we didn't talk about this, but I know that your aspirations and setting the things that you want to set in motion, for example, the technological upgrades, how does that actually physically happen? Who do you turn to? Who gets the memos? What do you set in motion?
So I'd work with the Chief Court Administrator, and Deputy Chief Court Administrator, and first getting a handle on the budget and what we can do ourselves. But part of that plan will require working with the legislature. So some of that is resources we're going to need, but the levers I would have is just clear direction from the top. If I say we want to go in this direction, the judicial branch will be able to marshal resources in that direction. So I think it's going to start with clarity from me on what we need to do, and then the branch will order itself around that.
And in our conversation a couple of weeks ago, I had urged you to be, I said you're very young, and it's in all your written materials, but if you could just say for the record your age.
46.
46. So you're becoming Chief Justice at the very young age of 46. So I think you have so much ahead of you, assuming that all goes well. One of the things that we discovered in years past was that there was a breakdown of communication. Again, so much was paper records stashed away, hard to retrieve. And there was a breakdown between Board of Pardons and Paroles, probation, and some very, very horrific killers that got released that maybe should never have been released. And so we as a legislature set in motion the creation of the Criminal Justice Information System, CJIS. And to my somewhat dismay, it's taken just an inordinate amount of time to get that up and running. And I think it's still sort of plodding along. Whereas sometimes in the land of steady habits here in Connecticut, we're not smart enough, I think, and that's my own judgment, no one else's, to just look at other states instead of trying to create it from whole cloth ourselves. And we like to sort of like make sure everybody has input and stuff like that. But a lot of these things have been done in other states, and they're way further down the road, especially technologically. So I would just say that as you progress down that path, we don't have to reinvent the wheel. It's already been created out there. And I think we have 49 other states that are laboratories for change. And I would say just pluck it up and bring it here so that we can move down this path faster. One of the other areas that we chatted about was, and again, tangentially to the technological changes you want to put forward, is when I went and visited the Yukon campus at Storrs, and we just recently, as a legislature, voted on a bond package. They got a lot of what they were looking for, and they had buildings that were under renovation, and they ground to a halt because they discovered asbestos and other things that caused their renovations to stop. And one of the buildings I remember is right next to Life Sciences, and they wanted to upgrade Life Sciences that was probably built in the 60s. Not that it's falling apart or anything like that, but to attract the best and the brightest from around the country to come to Connecticut and be our professors and researchers. And so one of the things that we chatted about, and if you could just like illuminate for the folks in the room and the folks watching, we have all sorts of kind of physical facilities as far as our courthouses. The one across the street, our Supreme Court building, I think is just gorgeous. And if it's not on the historic record, it should register, it should be. It's just amazing. But as much as some of these architectural facilities are gorgeous, they're not functional. And you may run into the same problems like in my house, I tell my kids, you're not putting that picture on the wall because it's plaster and it's going to crack and you're going to have to come up with a different plan of attack. So when you have an older facility, you have to approach its modification differently. What do you feel is that one of the impediments in bringing us forward technologically?
It is one of the impediments, and it's why part of my longer term goal is to really sit down and assess whether it's going to make more sense to try to upgrade those buildings or build newer buildings. You mentioned asbestos in our conversation. I said some of our buildings are very old, so if we want to get Wi-Fi and we want to wire them to be technologically advanced, we may have to open up walls, and that's going to cost potentially just as much or more to abate asbestos and get the building up to code versus building a new building. That's a more comprehensive plan that I want to look at and put in place. And maybe that will be a feasibility study to just see what are we looking at? What are the numbers if we update this building with all the upgrades it would need or try to build a new building? The cost may be relatively similar. But to answer your question directly, yeah, that's one of the impediments. Some of our buildings are beautiful on the outside, but they're older.
And sort of taking a little bit of a different tact, I recall in the last year or two, Chief Justice Robinson came here, and part of his concern was safety within the courthouses. He wanted us to consider enhancing penalties for threatening judges and other folks working within the court system. We sort of have a predilection regarding raising penalties regarding criminal matters, and that was a difficult sell. But also tangential to that is just the difficulty of getting marshals in the courthouses. I know that up in my neck of the woods, GA 13 was sort of repurposed. It wasn't able to serve its purpose as a GA, to my sadness and consternation, although Judge Carroll tried his best to keep it going. And I think it's been repurposed to a marshal training facility or something like that. But being up on the Massachusetts border, we didn't have the ambit of service territory that probably would have helped it. But also just there's a difficulty in finding personnel for certain areas in our society. So I go out into my district and there's businesses just looking for skilled workers in certain areas. And the baby boomers are retiring, dispersing as much as folks want to volunteer their services. There's certain crying needs for certain educated workers in our workforce that we're having a hard time meeting. What is your idea about trying to meet the ever increasing or demanding job necessities for keeping the courthouses all up and running?
That's difficult. We have difficult time retaining marshals. That's difficult. Part of my longer term plan is if we are in a position to consolidate buildings, then we won't have as many buildings spread out to staff. We'll have fewer buildings with less staffing needed. But that is a recurring concern of safety of the judges, safety of the public and the people using our buildings. So part of my plan is when we build these new buildings, technology is important, but designing them in a way that maximizes safety for the public and the judges is also important.
And one of the things that I had said, that don't be a stranger to this side of the road. I know that Chief Justice Rogers did not hesitate to walk across here, especially if we had a new batch of potential judges. And she would just sit there, and I think that her support physically and morally was helpful. And it's good for us to have that kind of communication. And I'm working on trying to get that bench bar dinners that we had under Jay Jackson back and running. So we'll see where that goes, and I'll keep you informed of that. The last area, and I know that my constituents always ask me because they don't know the difference in many respects between how Washington operates and how Hartford operates. And I try to say, yeah, there's hot button issues. There's things where Republicans and Democrats disagree vehemently. And we're not afraid to dig in our heels and talk till the cows come home if we have to do that, and vice versa, depending on which side of an issue or the aisle that you're on. And there's nothing wrong with that, but it's certainly not as rancorous or as difficult a situation as sometimes Washington is perceived to be, rightly or wrongly. It is not unusual in the modern era to see if a Republican president puts forward someone to sit on the United States Supreme Court, that every Democrat will oppose that person, and vice versa. And that's unfortunate. And someone said, gee, John, like when Governor Lamont, a Democrat, put you forward, are you going to like just run out there and oppose? And I said, no, that's not how we operate here in Hartford. For my constituents' edification and for those that might be watching, I'm just wondering, we don't have that kind of disagreement as pervasively as is evident in Washington for a variety of reasons. But I'm just wondering if you could describe your judicial philosophy, because I've heard from folks, Republicans, Democrats, people out there in the criminal side, civil side, and everybody has sung your praises. They just think that you're inherently fair and balanced and not easily pigeonholed conservative or liberal. And I'm just wondering what philosophy you bring to jurisprudence, and what can we expect as Chief Justice for your leadership to maintain and continue as far as deciding who's going to write majority decisions and how the court is going to function.
Sure. So for me, I don't really love judicial philosophy. And partly it's because I think you deal with the issues that come before you. And I think if you're judging appropriately, you're trying to be impartial and fair while at the same time considering the circumstances of the case. I don't approach cases with an agenda. I'm really just trying to get the right answer for the people in front of me. And if you do that impartially, or you at least do the best you can as a human to be impartial, I think it's going to be difficult for you to always be on one side of an issue or always on the other side of an issue. You will take the issues that come and deal with them. So if I had to say what my judicial philosophy is, I don't love judicial philosophy, but it would be judicial restraint. I try to not decide more than what is presented to us. At the Supreme Court, you have to petition for certiorari. That's how we get the bulk. Petition for certification. That's how we get the bulk of our cases. And you ask the court to hear a particular issue. As you get into issues, there are always times when you see tangential concerns or how this may affect another area, and it takes some concentration to make sure you're answering the question that was asked, that was put forth, that we granted cert on. That's how I've approached judging, and that would be my philosophy, to exercise judicial restraint and not go beyond the issues that are before us.
Well, I think that's really heartening. It's wonderful to hear. I'm a pragmatist in many respects here in the legislature as well. I know from my days back in law school, they said stick to the four corners of the decision. Don't try not to go beyond it. And I think that the people of the state of Connecticut will be well served. It would be remiss of me if I didn't thank all of your supporters here in the room. I got the opportunity before we started to meet your dad. And I know that you have two sisters. It's got to be competitive around the Thanksgiving table when everybody gets together, but what a wonderful family. And the other thing is this, just on a human level, the fact that you had a child so young in your life and it didn't slow you down, but it almost seemed to like supercharge you in your life's attainments. Maybe the lesson there is having to be very responsible. And some people might have looked at that as it's just going to send them off in left field, but it didn't do that in your life. So there's nothing that is going to come at us out of the blue that we can't get our arms around and work with and still grow and blossom, God willing, here in our society. And again, before I turn it back over to Chairman Staffstrom, you had indicated that there are courtrooms where I believe that you were alluded to people of color that were not treated as well, and how wonderful that you've been able to serve as a judge and appellate court judge, and a Supreme Court justice, and now the Chief Justice. But one thing that is always heartening to me, especially as I travel between the Capitol and the Legislative Office Building, I mean, we had people like Harriet Beecher Stowe who wrote stories bringing to the fore the plight of people in slavery. We had Prudence Crandall who taught young women of color. Connecticut, for all its faults and its trips ups along the way, and we're certainly not a perfect New England state by any stretch. I think we, as a New England state and as a state in these 13 original colonies, in the United States for that matter, has an awful lot to be proud of, and that we have been at the forefront of race relations and being fair to people of all race, creeds, and colors. And I think that that is a very proud heritage, and that you're here on your merits. But it's an extra bonus that you're of color. And I think that it just, your philosophy is what's going to help us move forward into the future. So congratulations once again to you and your family and everyone else that's here in support of you.
Thank you.
And again, thank you to Governor Lamont for his nomination. Thank you very much, Chairman Staffstrom.
Further questions from the committee? Representative Fishman?
Thank you, Mr. Chairman. Congratulations, sir, on your nomination. No matter what some people say, we are the land of opportunity, and congratulations that you're sitting here today.
Thank you.
I don't do meetings. They probably told you that. Don't even bother calling them, because this should be an open and transparent process. I don't like when there's discussions behind closed doors that don't come before us. The public doesn't see it. So that's the reason why I don't do that. So it's not out of disrespect or anything like that. I just wanted to ask you, you were in New Haven Superior Court. You sat as a trial judge, and what was your assignment? And that was February of 2012 through September of 2013. What was your assignment at that time?
For the first 9 months, my assignment was the GA. So, court, if you know New
Oh, yeah.
Haven, courtroom A. So I was in courtroom A first. I was in the domestic violence court for a bit. Whatever was going on in courtroom A, I would handle things in that courtroom. After that, I went over to Church Street to do just trials. We wanted to sort of clear up some of the backlog, and having someone dedicated to just do trials.
Once
on
again,
Church
criminal
Street.
trial.
Criminal trial.
Yep.
New Haven is unique in the sense that when you're on Church Street doing criminal, you actually do civil short calendar. So I did civil short calendar in New Haven and jury trials.
Okay, and then you went to Rockville, and what
Yeah.
did you handle there?
Rockville, some of everything. Housing, habeas mostly, helped out in the GA, some of everything in Rockville.
What about family?
Maybe pinch hitting family once or twice, but no steady diet of family in Rockville.
Okay. I do share with you, I did go to Xavier, but we could only deal with each other for a year. They threw me out, and those records have been expunged. But I know it to be a fine institution, and anyway. The Code of Evidence Oversight Committee, in that role, do you compare the Code of Evidence to the practice book?
Do we compare it? we do in the sense that we want to make sure it's consistent. There's sort of a difference between what a practice book rule would be and the rules of evidence. So we make sure that there's no overlap and really think about whether um, any particular issue under consideration is better to go through the rules committee or is really just a pure evidence matter that we should deal with.
Okay, that's fair. You know, sometimes they do overlap,
Yeah.
like 13.4 of the practice book, which deals with experts.
Expert, yeah.
There's a lot of information about in there about documents being produced, all of that stuff, and invariably those documents potentially are going to be entered into evidence at trial, right? So then you're out of the practice book, you're in the code of evidence, and you're having to deal with both to a certain extent. In you cited the case, State versus Holmes, which I didn't get a chance to review. And you have a recollection of the case.
I do.
Yeah. And what systemic problems were being dealt with in that case? You characterize it as systemic.
Yes. So Holmes was a case where we dealt with picking jurors and the Batson rubric, where the United States Supreme Court attempted to put in place a procedure to deal with discrimination in picking jurors. Previously, there was a serious problem with striking black jurors, some female, but mostly striking black jurors at using a peremptory challenge, which you have to give no reasons for. You just strike black jurors, and it was discovered that there was some racial undertones to doing that in some trials. So the U.S. Supreme Court came up with Batson, and it's a test to sort of see if you are striking this person based on their race. It's a sort of three-part test. You go through all the parts, and that test, we also use it in Connecticut, but Holmes was our way of addressing that specific issue, discrimination in picking a jury, particularly with peremptory challenges. And I don't know if the
No,
rest of your question is.
Well, I want to
my
interrupt
thought on
you.
it.
So Batson was many, many years ago.
Yes.
Supreme Court.
U.S. Supreme Court.
Yes, the U.S. Supreme Court addressed that. And what I was trying to put together is how is Batson not sufficient? Because certainly the Connecticut courts on some planes adopt U.S. Supreme Court jurisprudence, precedent, and all of that stuff, incorporate that into our procedures. But here something was lacking, right? The U.S. Supreme Court says something, but Connecticut doesn't take it, and the case ensues. So what was the difference?
So we took it. We were applying the Batson rubric, but I think Holmes was a recognition that Batson just didn't work. So basically what you do is you strike a juror, you use a peremptory challenge. The other side can say, hey, I think that was a race-based discriminatory challenge. Now the burden shifts for you as the prosecutor to give a non-pretextual reason for the strike. It's discovered, I mean, if you look at a significant number of Batson challenges, the pretextual reason was almost always sufficient. And you rarely get to the third step, because now when you give the non-pretextual reason, burden shifts back for you to demonstrate how that really was a pretextual reason. So Batson was going along a path where there were almost no successful Batson challenges. I think in my research, I remember one, but there was like a smoking gun found where there was a document where the prosecutor said, I want to strike this person because they're black. But without that, you can raise the Batson challenge, then the burden shifts, and you're almost always able to offer a pretextual reason. Holmes was, I think, a good recognition of what are we doing with these challenges? And we in Connecticut said, well, let's study it. There was a jury task force. They studied it and they came up with recommendations on how to better go about addressing those types of challenges. So I don't know that I'd say we just don't follow Batson. We followed it for years. We just also now have thought been more thoughtful about how these challenges go, studied the problem, and are coming up with ways to make sure we get jurors who can serve and aren't sort of taken out because of discriminatory reasons.
Yeah, I had heard of Holmes, as I said, I hadn't reviewed the case, but it was my Batson sort of opened up the door to this concept that this was going on.
Yep.
This is bad. We need to do something. But Holmes, which is a 2019 case, if you look at the time period, that's the last, 6 years ago, right? So, okay. And the last area, as a policymaker, um, and I'm focusing on question number 9 of your questionnaire. The question is, what areas of law do you enjoy the most as a judge and why? And you say, I enjoy the areas of criminal law and juvenile law the most. These are the areas that most frequently touch the most vulnerable people in our society and frequently force us to engage with constitutional provisions. I wanted to give you a multiple choice. In our system today, which one is the most vulnerable? A first-time arrestee for a DUI, a first-time juvenile arrested for a car theft, or a mom with 3 children aged 9, 13, and 18 going through a divorce for the first time?
I may need to know more of the circumstances of the mom, but my gut reaction is that's affecting more lives. The mom going through that situation. If we're talking about the question in the questionnaire as it was posed, there aren't always constitutional issues there, but that would touch on one of the reasons I answered that juvenile law interests me. It's not completely separate from some of the issues you see in family. And in your example, that's going to lead to some issues of family integrity in the third example. So on some level, I don't see it as inconsistent with my answer to say that the mom going through a divorce with 3 children, I would need some more context, but generally that's going to affect more lives.
Yeah, well, and I agree. And I just ask that as you travel on, that you keep your eyes open to those moms.
Yeah.
And those dads, because, a lot of our jurists don't realize there are constitutional rights there. When somebody's kids are going to get taken away, that's a constitutional right? So if we unpack a little bit, the first time DUI person, let's say they're unrepresented, they're going to go meet with the prosecutor. The prosecutor's going to say, go fill out that form for the DUI, the diversionary program, right?
Mhm.
That case is going to get dismissed. The second case, the first time juvenile arrested for a car theft, same thing. They have a diversionary program. Both of those 2 areas that you say are the most vulnerable have these wraparound services through our system. But the mom, when I started to, 5 years ago, the mom could go to court. She could file a motion with the court. She'd get on a short calendar. We had short calendar for like you had the civil cases.
Yep.
Short calendar for family. Now, that mom, she files for a divorce. She's got a return date. Return date's, usually about a month away, right? Case gets filed in court. 45 days later, there's a resolution plan date, an RPD. Resolution plan date, that term doesn't appear in statute, doesn't appear in the practice book. It was something that was just created and implemented. And on the RPD date, mom still doesn't get relief. It's not a hearing date, right? So under the old system, mom could be in court about 2 or 3 weeks after the case is filed. Now, given my timeline, case is filed, 30 days, 45 days later, you're there for an RPD. doesn't resolve. She's looking for some sort of, she's looking to get, let's say, dad out of the house because he's creating a bad process. You're gonna get a hearing date. Courts are all backed up. You know, I was talking with one of your fellow justices who was telling me that, you know, he had heard of a case where it took a mom like that 7 months to get some relief from the court. Something has to be done here because these people also have constitutional rights. You know, through the pandemic, we had and I'm sure you heard about it. Any judge who touched family heard about all of these ex parte applications that, you know, people attempted to get custody through saying that it was an emergency, and they would make up things. I'm in the middle of a trial right now where a woman 3 times filed a restraining order application, filed for emergency ex parte custody, and just lied on her application. Those kids were taken away from dad, actually, and put in her care based upon that. There has to be a lot of attention given to this, you know, both parents, because criminal court, juvenile court, a lot of wraparound services, but there's a lot of pro ses in family court. And you know, I don't know what the answer is, but I just ask you to keep your eyes open on that, and you know, certainly reach out. Once again, I congratulate you on your nomination.
Thank you. And I will keep my eye out on that.
Further questions or comments from the committee? Representative Osborne?
Thank you, Mr. Chair, and thank you so much for being here, Justice Mullins. Congratulations on
you.
your nomination. Unlike Representative Fishbein, I did take the opportunity to meet with you because when am I, as a practicing attorney, going to have an opportunity to speak to the next Chief Justice of the Supreme Court for an hour, a captive audience? You bet I took that opportunity. So thank you very much for meeting with me and sharing with me some of the answers. I'll go through some of the things that we discussed very briefly here. But first, I would like to reiterate the concerns I heard articulated by Representative Fishbein with respect to the new program in family court. It is arising in some levels to a due process consideration where motions are filed and they will not be calendared if they're filed at a particular point in time. And there's no way, especially for self-represented litigants, to understand that filing a motion doesn't mean they're going to be heard in court. And so I would just like to reiterate that from Representative Fishbein. But in particular, with respect to your questionnaire, there was a question about, do you believe that an appellate, I have to take these off because I'm not old. Do you believe that an appellate or Supreme Court judge should substitute his or her conclusions on the issues of fact for the finding of the trial court? For example, would you substitute your findings for the trial court's finding in family matters, which are usually upheld on appeal? And in just paraphrasing, you said a bunch of very, very smart things. And then I would not make findings of fact as an appellate judge, nor would I substitute my findings of fact for those of the trial court in family matters. And obviously what you're referring to is that the standard on the appellate level is clearly erroneous for evaluating the factual findings of a trial court judge. And specifically, I'm speaking about family court judges. Family law, as you and I discussed, is an incredibly complex area that is much more difficult to understand in a really nuanced fashion if you have not actually practiced in family law. There are a lot of almost social science overlaps with what we do. But for those of us who are very interested in practicing family law as law, it's especially important that the judges who are sitting in family court do understand that law, which can be very complex. And my question is, would you agree that because of this very high standard, this clearly erroneous standard, which it can be very, very difficult if you're sitting at the appellate level or the Supreme Court to evaluate on the basis of a transcript that may have been submitted or any of the other appellate submissions, it's a really high bar to get to clearly erroneous. And wouldn't you agree that it is more likely to have fewer errors in the findings of fact if the judge is sitting in family court, have some sort of family law experience before that appointment?
I'm not sure if I'd agree. I mean, just as a general matter, more experience in an area is always better. You'll have a better facility with the law, but the factual findings are, the court receiving evidence, making credibility determinations, looking at the evidence that's presented. So I'm not sure I'd go as far as to say that there'd be less errors on a factual determination, because that's basically looking at the evidence that you have. The standard for what that evidence means in relation to the legal issue, well, that's where we're going to review, and the standard isn't as high. So to try to answer your question directly, whatever the facts are, they have to match up to what the legal issue is. And the legal issue we're going to review with more deference than we would the factual issue.
Do you agree that it's easier to discern between complex fact patterns if you've had experience doing that in your job before you become the judge in that matter?
Potentially, because you'll know what legal standard you're trying to meet. So you may see evidence in a different way if you have experience doing that. Yeah.
Well, thank you very much. Thank you for being here today. I was honored to meet with you the other day, and I look forward to the rest of today's proceedings. Thank you.
Thank
Good
you.
luck. Thank you, Mr. Chair.
Senator Sampson online.
Thank you very much, Mr. Chairman. And good morning, Your Honor. Congratulations on your nomination, and thank you for being with us, of course. Very interested in the conversation we've heard so far, and I want to just follow up some of the comments Senator Kissel and Representative Fishbein made with regard to how we do things, and our differences with DC and so forth. Some might argue that those are deficiencies, but that's another conversation altogether. I have a couple of questions. I just want to speak with you generally, and then I have a more specific question. And the first one really has to do with question 5 that is on the survey that we provide and you've responded to for nominees. And this is the one that asks about, do you believe the Connecticut Constitution provides the same rights and protections as the U.S. Constitution, et cetera? And I have an issue with the question itself, because for someone like me who is a conservative Republican, I believe that rights come from God or a creator, if you will. And so I don't really like the way the question is worded to begin with. But in your answer, you respond by saying that you believe the state constitution provides greater rights and protections than the federal constitution, and that also states are free to develop constitutional rights and protections separate from federal guarantees. And I'm just curious whether or not you adopted this use of wording from the question, or if that's really your view that rights come from government, or whether they come from God and the duty of government is to preserve those rights.
Yes, I was answering the question specifically and what was asked, and some of the language does track the question, but in actuality, that's our system. The federal constitution does provide some rights, and the state constitution also provides rights, and we can provide greater rights than the federal constitution.
Right. Maybe some of this conversation has to do with, how we're using the term rights. I noticed also in your answer, you mentioned that, for example, the state of Connecticut provides a right to education. And I know that's commonly held and people use that terminology all the time, but the word right doesn't appear in the Constitution with regard to education. It's simply, in my opinion, I would more accurately describe it as a guaranteed entitlement, because it's something the government is providing. For me, rights are something that you have naturally, and that the government's not in a position to do anything except for inhibit your access to that. So I don't know if that really helps me. In the political realm, the tension between the political parties is between what the role of government, I would say the role of government is to protect rights and to advance the cause of citizens being able to achieve on their own. And others might argue that the government has a much larger role to play in how we live our lives. And I don't want to put you on the spot to make a political determination, but for me, it's with great interest when I am, faced with, voting on a nomination, whether or not that judge or justice in your case, shares my worldview that the role of government is to effectively protect rights that are already held by citizens, or the government is there determining what is allowed by citizens.
So I will answer it this way. I was not answering that question sort of philosophically about where rights come from and what rights are. I was answering solely in the context of what was asked about the United States Constitution and what it contains and what our state constitution contains. And as a judge, I wouldn't profess to make those broad political statements about where rights generally come from. So I simply was answering, in question 5, I was answering exactly what was asked about what's in the federal constitution and how that relates to the state constitution.
Understood. Okay, and forgive me, I don't. My intention is not to press you on the subject. Really, I was just trying to get a more of a philosophical worldview kind of response. But I'll just move on. One of your comments this morning, you mentioned judicial restraint as a priority, and it leads me to my second question, which is regarding the Soto versus Bushmaster case. And maybe you could just describe for me your thought process in siding with the majority.
I'm hesitating only because I hadn't researched whether the case is fully resolved. We had the case addressing some preliminary issues in the matter, with whether summary judgment would be proper. And so once we decided, the majority decided that it wasn't, the case went back for further proceedings. So I'm very hesitant to make a public comment on a case that may come back to us because of the rules of judicial conduct. I can't make a public comment on a pending case or a matter that might come before us, because that would lead to me having to disqualify myself in a case. And the code sort of speaks to not putting yourself in a position to have to disqualify yourself.
Yeah, I certainly understand. Through you, Mr. Chairman, and I don't want to put you on the spot once again, but this is an important issue for me. I mean, as far as I know, the case has been resolved. I mean, Bushmaster settled out of court, but you're right that I don't know that the individual circumstances of what was before the Supreme Court has been finally resolved. My understanding, reading the majority's opinion, which I know you didn't author, but you did agree with, is that effectively the federal law that provided for the firearm manufacturers' protection from liability allowed for a predicate exemption. And the facts in this particular case that was before you was really about whether or not the Connecticut Unfair Trade Practices Act could apply in that regard. And I'm a non-lawyer, by the way, Your Honor. So this stuff is a little deep for me, but I spend a lot of time and energy trying to understand it fully. As a lawmaker, I feel like we have an obligation to truly understand. But I'm looking at this case and seeing that not only for me did I think it was a stretch to impact firearm manufacturers by using CUTPA as a mechanism to get at something which I think the federal law implicitly was designed to protect against, but also just my concern over, the expansion of the Connecticut Unfair Trade Practices Act itself. again, if you don't want to comment on it, I certainly can't force you, but I would love to hear your view. There are people that are certainly paying attention to your nomination from a standpoint of concern over where you fall on the Second Amendment, the rights of firearm manufacturers to engage in advertising, and more importantly, just anyone, businesses in general, being able to engage in trade practices without coming into conflict with a widely expanded version of that Connecticut Unfair Trade Practices Act. So any insight you can give me into any of those questions will be valuable in determining how I will vote. And I'm certain that there are other folks on the committee that are interested as well, and certainly folks that have contacted me knowing that I would be here today in this position of asking you some questions. And I'll leave it at that. Please share anything you like with me, and I appreciate your time and your willingness to be before us, and you're willing to serve on the court. Thank you.
Just before you begin, Justice Mullins, just so we're clear, you know, we certainly as a committee understand, and going through this, know you can't comment on pending cases. So if you're unsure whether the particular case is still pending or may come back, please leave that out. If you'd like to generally address the question, you know, as the good senator said, feel free, but please do avoid the specifics of a pending case if you could.
I appreciate that, and I was going to. How I would answer your question is, you could look at my record, and I have a full record now from the appellate court and the Supreme Court of cases that I've authored, and I think you would be able to see that when the issue comes before me, I don't have an agenda. I am truly trying to decide what's right in that case. I'm not necessarily interested in expanding CUTPA, but I'm interested in trying to get to the right decision in each particular case. So for your constituents or for your own edification, that's the approach I've had, and that's the approach I'm going to continue to have, and that will be to exercise judicial restraint and decide only the issues that are before me.
Thank you. Senator, all set?
Yes, sir. Thank you, Mr. Chairman. Yep.
Representative O'Day.
Thank you very much, Mr. Chair, and thank you, Your Honor. Sorry, I'm not there in person. I did have the pleasure of meeting with you individually or with a group, and I appreciated that, Your Honor. Just a couple follow-ups to particularly the ranking member, Representative Fishbein. You know, the family law, I do believe, needs major changes. And as he stated, I don't have the answers either. But we do need to give it, as he said, a lot of attention. And I'm wondering if you've thought about or seen the fact that there is a problem in our family court system.
I have thought about it, and I do think that we are making progress, certainly from where we were with COVID. I've heard the concerns and I understand them. So it's something I will be taking a closer look at and being more involved in. But I do think we are making progress from the old system. Any new system is going to take some time to work out. I think the thought and the interest was there to better serve the public. And so that's where I think the judicial branch is coming from with the new system. And there may be things we can work out. Maybe we include more hearings. I know there was a time when we didn't have hearings in between your initial hearing and your RBD date. But we've instituted those, and there are more hearings, and certainly we could work on that. That's something I will be interested in figuring out.
Thank you. And I will tell you, certainly having more hearings than what previously is good, but I would tell you, Your Honor, there are spouses, both husbands and wives, that are filing motions for modification or some request for advice, and one just happened, and somebody, I don't do family law. It's not in something that I'm interested in doing as a practitioner. But there are husbands and wives that are waiting 6 months for a hearing date, which I find frankly unacceptable. And I'm not blaming the judiciary necessarily. I think it's probably a staffing issue. But I would submit to you, Your Honor, if somebody files a motion for modification or for a status conference in civil court, I can get a status conference within a week, maybe 2. In family court, it's even more important than I would submit potentially life and death importance on getting a hearing right away. So I would ask Your Honor to make that a priority. I know updating the records, digital records for juvenile is a priority, and certainly that is. But I would submit to you that even a bigger priority is making sure that if in family court a participant needs a hearing or files a request, that something be done within a few days, if not a week, within a week. And I'd ask you to look at that. You and I went through your questionnaire, and I was pleased to hear from the good ranking member that he didn't have too much punctuation questions for you. And I say that tongue in cheek, not because I'm downplaying it. I think you obviously spent sufficient time in filling out your application, and it reflects positively on you. And so I wasn't trying to poke fun at my good ranking member. I think he's correct in making sure people take this form and this questionnaire seriously. In question 21, you were asked, what attributes, do you believe an appellate judge should have in order of priority? I didn't see humility until question 22. And I'm just wondering why that was not put in 21.
Maybe you found the one oversight. It probably is something that to me is so central to becoming a judge in the first place that others were on the top of my mind. But if I did the questionnaire over, humility would be almost, in my mind, a foregone conclusion for a judge.
Thank you. Yeah. And, the Robitis question, Your Honor, you've got a sufficient amount of history on the bench such that your reputation precedes you. And I don't think anyone would question the fact that you would not suffer from Robitis as the Chief Justice, particularly in how he answered number 22. But do you see any change in your judicial temperament going into the position as Chief Justice?
No, I don't see any change.
That obviously is good to hear as the Chief Justice. And we talked individually about, being a younger jurist as Chief Justice, I would say, at 46, but you appropriately pointed out, I think you're the only one with any grandchildren sitting on the Supreme Court. Is that correct?
I think one other justice finally had a grandchild, but mine are certainly older than everybody else's grandchildren.
Well, Your Honor, congratulations. One of the things, at least from this side of the aisle, I would say is legislating from the bench is something that we would frown upon. And it sounds like from your responses, that is not something you're inclined to do. Is that fair to say?
That's very fair to say.
And I won't ask if you're willing to serve anywhere in the state at least 9 to 5. As Chief Justice, we pretty much know where you're going to be. So I congratulate you on your nomination. I appreciate your responses and look forward to seeing what changes you bring about. Hopefully with a focus on the family law system, family law practice, because I think that's an area which has the greatest need for improvement in my estimation and what I've heard from my constituents. So thank you, Your Honor. I appreciate your time.
Thank you.
Further questions or comments from the committee? Okay, let's go with Representative Porter first, followed by Representative Callahan.
Thank you, Mr. Chair, and still morning. Good morning, Your Honor.
Good morning.
Let me first say congratulations.
Thank
you. This is the second best moment for me sitting as a member on this committee. Tremendously honored and privileged to be able to vote for you. The first go round for me, but the second go round for you. And having you sit here today as a nominee for Chief Justice, I'm personally calling this the best parting gift this legislator could ever have. And I am getting a little emotional, and I apologize for that. But just having you sit here, having you present, having you answer these questions in the composure and the capacity that you are doing is something that we don't get to see a lot of when it comes to people that look like us. It's a lot of televised things that go on that hype all the negativity. And I'm sitting here just taking it in because this is my proudest moment. So I can't imagine what this is for your family, for your wife, for your children. And the thing that I thought about was your age, right? And not in a bad way. Because when I thought about it, you have actually come before us and really validated what it was I had thought about when I thought about your age. Not only what you've done up to this point, but the fact that I said, okay, 46, what does that look like? The highest court in the state. An opportunity for growth and development, you laid it out, right? Not just what you would do new, but what you would enhance, what's already in effect. The diverse perspective that you bring to the bench, every bench that you've sat on up to this point. It excites me that that kind of diversity can be, and I believe in speaking those things that are not as if they were, will be, right? Represented on the bench. The mentorship and the influence, so desperately needed in the world overall, but specifically in communities that look like ours. We learn through modeling, and your modeling has been exemplary. You have set the bar really high. So I think it's apropos that you sit on the highest bench in the state. And I'm excited that you are not afraid to fix things when they're broke. State versus homes. It wasn't working. It takes courage, right? Intestinal fortitude, political will, you know, to get things done. And I like the fact that you operate from, you know, a lens of judicial restraint. I find that to be a good thing. And so desperately needed, right? When you talk about making the kind of decisions that judges have to make and, you know, impartiality and not being biased and all of these things that we know do exist in our court system. So, I mean, I have no questions for you. I think you've done an outstanding job answering the questions that have been presented to you. And since there are no age limits or qualifications for this, I really think that for me, that's a moot point because of all that's been stated, not only in your questionnaire, but in your answers to the questions presented to you today. You have truly done something that I stand firm on, especially as a leader. Write the vision and make it plain so that those that read it can run with it. I'm excited for those that will have to, you know, see you as the leader and abide by what you see, your vision and your mission for this state. And I wholeheartedly believe that it is for the people, all the people. And that is what's most important to me because I'm still living to see justice for all. not just in the state of Connecticut, but in the world. So you give me great hope. I'm just excited, and I'm very, very proud of you. So thank you for doing all that you've done, despite the challenges that you have had to face from a very young age. You have really been a testament that I think everybody should take notice of. And I want to see this on the front paper, front page of the news today. So for all the media folks here, let's make sure we do justice by the individual that is sitting before us, the Honorable Raheem Mullins. Thank you, and thank you, Mr. Chair.
Thank you, Representative Porter.
You're welcome.
Representative Callahan?
Thank you, Mr. Chairman. Good morning, Justice
morning.
Mullins. Good to see you again.
You too.
And I do thank you for taking the time to meet with me last week and to maybe pull back the robe and see what you're made of. And it was a great meeting. But I do have a couple questions and a comment. To my knowledge, you are one of the few chief justices who will have served at all three levels of the court. And how would that experience assist you or inform you in the position?
I think in a couple ways. At least one, it gives me an appreciation and respect for trial judges and appellate court judges, what they're going through. I remember what it's like to be a trial judge and an appellate court judge. So in terms of any initiatives I have or anything I'm thinking of doing with the branch, I'm always thinking about what it was like to be a trial court judge and an appellate court judge. And also just knowing the system from those different angles, knowing the Superior Court, the rhythm of the Superior Court, the appellate court, and the Supreme Court. I think that all will help me in running the branch.
Okay, thank you very much for the answer. And if you could refer to question 3 on the questionnaire, and I congratulate you on the smallest font I've ever seen on one of these questionnaires. But
I did
it's
try to provide bigger font. So you
no, it's kind of different than my essays in college. I went with the biggest font so I could write less. But you say judges take a holistic view of the Constitution. What do you mean by that?
So the question, if I remember, is the question is, should judges interpret the Constitution to enforce the original intent of the drafters? So responding to that question, because it was in the question, I thought the intent of the drafters was sort of what the question was asking, should judges do when they interpret the Constitution? And they certainly should include the intent of the drafters. But I don't think that's all they should include. It's an important point. It's an important part of interpreting the Constitution. But to interpret a constitutional provision, you should be really trying to figure out what the provision means and what it's getting at. And the drafter's intent is certainly an important part, but there's other important parts.
Okay, I appreciate that answer as well. And just one more question, if I may, Mr. Chair. You're going to be the captain of the team, the judicial team. There are many employees in the judicial branch, and I was one of them for almost 3 decades. And how would you, as the leader of the team, try and make everyone statewide and all the different GAs and JDs feel valuable and part of the team?
Well, one of the things I plan to do right off, if confirmed, is visit all the JDs, talk to people, be accessible. I don't intend to sit in Hartford and never go out to see the different judicial districts and talk to people. I've found in my life talking to people gets you a lot farther. So very basic, very fundamental, but I plan to go meet with people.
It's a good answer. And one reflection, going back to how we met in person last week. When speaking to you and hearing your answers today, sometimes I'm in hearings and I walk away saying, what the heck just happened? You give concise answers. I know what you've said. You have a way of expressing your thoughts very clearly, which I think is important in the position of Chief Justice. But when we spoke, we talked about the personal responsibility that you took at a young age, and your dad I met your mom and dad before the hearing, and they made you take. It seems like these days when we're dealing with the courts, a lot of personal responsibility is not taken into account. And I'm glad to see that you took personal responsibility and your mom and dad made you take personal responsibility. And I'm sure that will carry over into your position. And on a personal note, when I was walking up the Supreme Court steps to talk to you, it was a bit emotional for me as you're sitting in the hot seat where my father sat over 2 decades ago when being questioned to be the new Chief Justice. And so I don't take how you feel sitting there and how my dad felt when he got home and talked to us. And I think he'd be proud to see who's sitting in that seat today. And I think you'll do a great job. And I appreciate your answers on the questionnaire. Appreciate your answers in person and here to when I met with you in person, one-on-one, and when we talked here today. So thank you, congratulations, and good luck for the rest of the day.
Thank you, sir.
Thank you, Mr. Chair.
Senator Mark.
Thank you. Good morning, Justice Mullins.
Good
Nice
morning.
to see you again. I really enjoyed our time talking last week also. And you've been very busy. Obviously, you've talked to a lot of people. When Representative Callahan mentioned your 3 having been at all levels of the court, I want to just go back a little further, as I did in our conversation, to your undergraduate degree in sociology and how that informed you as a new lawyer, as someone who then worked with juveniles, worked with the Department of Children and Family, and how that training experience as an undergraduate informed all of the work that you have done. And I really appreciated your answer. So I would ask if you could just give us a quick synopsis so that that goes into the record.
Sure. I think the undergraduate degree in sociology always made me curious about why people do what they do. What makes people tick? Why did this happen? What are the social influences on why people behave the way they behave? And appreciating that. I think as a judge, you should be appreciating the human experience. And sociology was my foray into doing that, into understanding, or at least studying why people do what they do. And that gives texture to some of my decisions and the outcomes, and thinking not just that, this person in front of me, they have a history, they have a life, they have things that have impacted that life. And taking all of that into account when I'm thinking about issuing a decision is important. And it started with studying sociology.
Thank you so much. I look forward to having you as our next Chief Justice if this all goes well.
Thank you.
Representative Fishbein for the second time.
Thank you, Mr. Chairman. I just wanted, on the family court plane, because you don't have a lot of experience there. One of the perils, when you sat on the appellate court and of course on the Supreme Court, you had no cases before you on a initial custody determination, because those are non-appealable events. So I'm just going to stress with you that those judges sit in a very powerful position. You get a divorce, custody motion is filed, there is a hearing at some point, there is a determination. That determination is insulated from any review, really at all, in some cases. So the matter would have to go to trial, final determination made, and perhaps that custody event that was determined maybe a year before is then attackable. I mean, I'm one of those kids at divorce. And, I'll tell you, my parents got divorced when I was 13. One of your children is 13, I believe. And that didn't bode well for me. Kids are in a very vulnerable position, and those justices or those judges have a lot of power. You did say about the new system that new systems take some time to work out. And yeah, most people don't like change, right? Unless they initiate the change, right? But I'll ask you to poll the staff. I have not heard from one acting judge, one case flow coordinator, that like this new system. The only people that I've talked to is the Family Relations Division, which I understand, and, you know, I don't want to get into what happens on short calendar day and all of that stuff, because it is, you know, it's like being in the emergency room of a hospital. It's a triage system, and I can understand how that can be inundating. But the new system, you know, I think if there's a morale issue, and I don't want to say there is, right? But when I'm hearing from boots on the ground at various levels that this system does not work, I gotta think it's not a positive atmosphere. You know, the more hearings, you know, courts are open 9 to 5, Monday through Friday, right? So, you know, we really can't say necessarily more hearings, because I know we had a case that we reviewed on a judge that came back for us to reappointment, and we had the opportunity to review the transcript, and that was a restraining order case, and there was no marshal in the courtroom for one of the one of the most contentious cases that we have in our system, because we know there's not a lot of courtroom marshals out there. So you could say more hearings, but if there's not staff to staff those hearings, that's a problem. And it's a funding issue also. I recognize that. And, you know, last but not least, Representative O'Day didn't want to ask you about, you know, 9 to 5 at any location. I will tell you that I would encourage the Supreme Court of the state of Connecticut to do more satellite hearings. You know, Quinnipiac has a fantastic courtroom. I know when I was a student, Sandra Day O'Connor came and spoke to us, and that was such an event. To have the Supreme Court come to Quinnipiac and to see justices argue, or you know, lawyers argue a case, I think is good for civic development. It's good for relations. It's a good educational thing, and I would just encourage wherever that could happen, that you look at it a little bit more often. So, thank you, and thank you, Mr. Chairman.
Thank you.
Senator Miller. Senator Miller with us online? Okay, how about Senator Lesser?
Yes, thank you, Mr. Chairman, and I also apologize for not being with you in person. First, let me just extend my congratulations to you, Justice Mullins, on your nomination. I know you don't technically live in our communities anymore, but Middletown and Cromwell feel immense pride in your professional accomplishments and in your nomination, and certainly your testimony today has been exceptional, and I wish you the very best in your new role going forward. Just a couple of questions. We're now 4 years out from the jury selection task force, and I was curious if you had a sense on whether the recommendations have been successful in diversifying the jury pool, if we have a better juries now than we did then. Can you just speak to that briefly?
Not quite yet. I will say I'm optimistic. We're sort of collating all the data that we've gotten in and assessing whether it's a better system. I believe it will be, but I don't have the hard numbers yet to give you a definitive answer.
And I'm assuming, based on that answer, thank you for that answer, that it's too early to tell whether or not you will be suggesting further improvements to diversify the jury pool.
Well, I will certainly be looking at the results, and to the extent I can, I definitely would be.
Okay, great. And then my last question is just about, I think Connecticut's a little unusual in not having individual calendaring. And is that something that you're moving towards? And can you give us an update about where that stands?
Yeah, I'm not sure. The IndyCal you're talking about, I know we tried it, but that's something I will also look into.
Terrific. Well, thank you very much for those answers. And Mr. Chairman, I appreciate the time.
Representative Curry.
Good morning. First and foremost, congratulations on today's nomination. So with Connecticut's population now roughly 40% non-white residents, and you now being what I believe to be the one and only justice who's a person of color. So what, I guess, will or can you do to ensure that the next nominee that the governor presents to this committee, filling the vacancy that's created by your ascension to the chief seat, will help us getting a court that truly reflects the people and the population of the state of Connecticut?
I'm happy to give the governor my thoughts if he wants them.
Any further questions, Representative Curry?
Well, I think if that's the answer I'm going to get, I'm sure I'm not going to get much more out of that. So I appreciate the time.
Thank you. Any further questions from the committee? Representative Miller, are you? Okay, if not, Senator Winfield?
Thank you, Mr. Chair. Oh, we still are. Good morning. Good morning.
morning.
It's good to see you again. My tenure on this committee is long enough that I saw you when you very first showed up, and I've been with you all the way through. So it's good to see you again in this capacity. I just want to start off by saying that I think it is good and important that you talked about remembering as a way of impacting the way you operate on the court, remembering history that is often forgotten even in this state. While some may feel that we've done a good job in this state, we had humans in bondage, and when we released them from bondage, we did it gradually. And so the system that we have here thought it was appropriate to do that. Thought it was appropriate not only to, when they no longer necessarily needed those humans in bondage, but to keep them in bondage for as long as they possibly could by that system. And so it's important to me the character of the folks who both sit here with myself and folks who are in your branch of the government. And so because I've been with you in a sense as you've gone through, I've had the opportunity to listen to you speak and gotten a sense of how you think. One question that always remains important to me, no matter who is in front of us, is the question that Representative O'Day asked about temperament, humility, robitis, if you will. But more important than that question to me is a question that I usually follow up with, which I will pose to you. It's the only question that I will pose to you beyond remembering and beyond the things that are around you. What is your system of accountability that holds you in a place where you don't get a little too big-headed, get robitis, that kind of thing? I think the answer to that question to me is more important than the yes or no in terms of whether you'd have robitis.
So you separated them, but I think it's front and center for me remembering the people that came before me, not just my ancestors, but my family. My parents gave up a lot for me to be able to go to a school like Xavier or a school like Watkinson. And I just don't, that's one major system of accountability for me. The pride that they get to have now is not the same as 1996 when my daughter was born and I made them grandparents in their late 30s. They had to walk around town and probably felt none of the pride that they feel today. So they've earned it. And it's important to me to continue to earn that trust from them. I have family members who have been on both sides of the law. I've seen what they've gone through, and to be in a position to have made it to where I am, it's important to me to remember that I have family members who aren't. I have friends who aren't. And it's important to me to treat this opportunity with the respect it deserves each and every day. From the first time I was appointed to the Superior Court, I saw many people in the New Haven GA that looked just like me and could have been me when I was 17. I could have gone a very different path and didn't. And that always makes an impression on me on how I treat people and how I approach the opportunities that I do have, because I could have been that kid that went a different direction.
Well, I thank you for your response, and I just briefly want to say something about the issue that has been with you since you first came here, the issue of age. This is one of the few places where a person of my age is a spring chicken. We're not, but people come here with different experiences. And I think when you first came here, you had experiences that clearly allowed you to sit on the bench and do a job that made you a person who would be considered to continuously elevate. And I think we need to remember that while someone may be young, the experiences they have are important. And I'll also say that once you sat on a bench and we got to see how you operated, that age thing should have disappeared because of the experience you had and what you brought to bear. In my mind, it did. And I think you have done proud all of us, particularly a community that looks and says we don't always, as Representative Porter suggested, always see what we hear as possible. That is important. It's not the only factor, clearly, but that is important for a lot of us, even in this late date of 2024. And so, for those reasons, I am glad to see you there, and I think you'll get a favorable vote out of me. Thank you.
Thank you.
All right, I think Senator Miller may have resolved your technology issues, Senator.
I'm trying. I can't get my video. Oh, there it is.
We can
Oh,
hear you.
I thought, can you hear me?
We can hear you, Senator. Go ahead.
Okay, thank you. So good afternoon, Justice. You're going to be nominated as Chief Justice. I want to say good afternoon and thank you for joining us today, and congratulations on your nomination. I just want to echo the sentiments of Representative Porter and Senator Winfield, that I am so very, very proud of you. And I hope that you share your story with other young individuals who, and just young people in general, regardless of race and color. Because I think it's a good story for individuals to know that you don't have to let your circumstances determine your future and your destination. And so again, I am so proud of you. Thank you for meeting with the Black and Puerto Rican Caucus. As chair of the caucus, I want you to know that we had written the governor a letter stating that thanking him for nominating you and also stating that we support you. So I wish you the best, and I know you're going to do an outstanding job, because there's something when you rise up, you work through the ranks, you're promoted through the ranks, because when you become a supervisor or a leader and you come up through the ranks, you have a different perspective because you've been at each juncture, you've been at each position, you've been at different positions. So it helps you to make decisions that you probably wouldn't have been able to make without those positions. So again, we're proud of you, and I know that you're going to build upon what your predecessor, the work that he's done. Thank you, Mr. Chair.
Thank you.
Thank you. Justice Mullins, I just have a couple quick questions to hopefully wrap us up here and get you on your way here. But first, I want to echo my colleagues and congratulate you on your nomination, and certainly thank the governor for putting it forward. I want to drill down on just a couple quick things. I know we had a chance to speak earlier or late last week as well. And I'm glad to hear you talk about sort of the litany of technology challenges that the branch faces. I guess what dismays me a little bit, though, is I've been practicing law in the state for 16 years. And when I first got sworn in to the bar 16 years ago, those same technology challenges were being discussed then. You know, the fact that you can walk into any federal courtroom in this state, and you walk in with your laptop and you can present your entire case on a laptop as opposed to having to lug boxes and copies into a state courthouse. The fact that our criminal courts are still being run like they were in the 18th century with an aluminum box, and God forbid the box gets spilled over, that kind of ends court for the day. So I guess I want to press you a little on timeline and when we can actually expect to see some progress and some movement. And relatedly, because I know you're gonna, I know this is related, is how we go about paying for those technology upgrades. I mean, yes, we as a legislature play a role. Yes, the governor plays a role, but there's no shortage of folks who come into this very room year in and year out asking for additional funding for additional things. And so I'd like to hear a little more from you on timeline and on how we pay for it.
So on timeline, I think we are much, much closer to a digital courtroom. The branch has received seed money to start a digital courtroom. So at this point, we are looking for an appropriate location. So in terms of the last 16 years that you've been practicing law to now, a couple things have changed. We had COVID. That forced us to upgrade some technologies to be able to have remote hearings. And we're capitalizing on that experience to try to see what we can do remotely. We've had to update certain things. A lot of that updating is underway with the criminal files. Some of the complication is getting all the systems that communicate with the court to use the same platform. Police departments, other departments that communicate with the court. Those are some of the challenges. I think I talked specifically with our IT department about this first technological upgrade so that we have the capacity to do paperless filings in the court, certainly in the criminal court system. And I don't want you to hold me too firm to it, but I think we're looking at probably a couple years. I think we're close. We are updating all of our systems. That has to happen first. And with respect to the digital courtroom, we're identifying a location. We have some seed money and we're identifying a location. Now, the rest of your question, it is going to require resources to maintain and to keep going. As I get into the position, I'll have a better understanding of where our resources are currently going and which could be diverted to this priority. But it's also going to require me working with the legislature.
So on the technology upgrades, I think one of the real frustrations I would submit, I think bipartisan frustrations this committee has, not just with the judicial branch, but frankly with several executive branch agencies right now, is in 2021, this legislature led by this committee passed nation-leading clean slate legislation. We made a promise to people around this state who had been convicted of crimes years ago that the collateral consequences of those crimes were going to be wiped away. And we set in place a timeline to do that. And as we sit here in 2024, heading closely to 2025, that promise has not been fulfilled. And I think there's plenty of blame to go around. I'm not looking to point fingers, but I guess I want to hear from you as Chief Justice, what commitment you have to making sure the judicial branch is doing absolutely everything it can to implement a clean slate, and not a couple of years from now, but now.
Certainly on that score, I'm very committed. As I mentioned maybe a few minutes ago, I have family members that have been on both sides. Something like clean slate is very important to me. It's very important that we make good on that promise.
On costs and how we free up costs within the system to hopefully pay for some of the needed technology upgrades. I mean, obviously facilities are one of them. You know, I, for one, would strongly encourage you to look at consolidation. I think we just have too many courthouses in the state. I know that's going to ruffle some political feathers. I know some folks aren't going to like that, but we have too many small facilities that we're trying to staff, we're trying to secure, and frankly, not doing a very good job at either of those when we should consolidate in. The other piece, though, I guess I would ask is, when we look at our pretrial detention costs in the state, we have a prison population right now of roughly 10,000 people, and 40% of those folks at any given time, approximately 40%, are being held without having been convicted of a crime. They're being held on pretrial detention, and that is a huge cost, not just financial cost to the state and to the system, but to those individuals and their families. And I guess I'm curious to hear your thoughts on how we reduce the cost of pretrial detention in the state of Connecticut.
I think that's a complicated question, and certainly something that I'll be focused on in addition to clean slate. I don't think I think we're doing much better in terms of low-level offenses and having people be detained pre-trial. But we could always do better. If people don't need to be in, they shouldn't be in.
I guess I was hoping for something a little more concrete. I mean, having been somebody who's come through the system, as I believe you were a state's attorney before going on the bench, right? And now having been through sort of 3 branches of government, I think most of your career has been on the criminal justice side, correct?
Yeah.
I know you mentioned you were in the New Haven courts as a criminal judge, et cetera. I mean, can you give me a little more? Can you give me some thoughts on where we are as a state, where we are as a system, and where we should be going?
I could give you a little more. It's sort of, in some ways, difficult because it's a broad question with numbers that we'd have to drill down on. So 40% are in pretrial. That number may be high. There may be factors that go into that number. I've started looking at some of the numbers of our detainees, and a couple things I noticed just being involved in criminal, that there are multiple charges. Some warrant sort of detention, and there's others that are tacked on to that charge that may not warrant detention, but that's not driving the reason for the pretrial detention. So it's the reason it's a little difficult for me to answer your question is because I'd have to drill down on those numbers. Now, that said, I think my original answer was I'm interested in drilling down on those numbers to see if people who are in should be in, and if they're not, they shouldn't be. And then thinking about the reasons why we're detaining people. So for me, it does go back to really looking at what those numbers are and what makes up that 40% number, and then where the problems are and addressing those problems.
I guess maybe this is my last question, but on so as somebody who has, and I think maybe this is a variation of the question Senator Winfield asked you, but as somebody who kind of came out of, say, the public sector, right? I think stop me if I'm wrong, but I don't think you've ever, you never engaged in private practice of law. You're always working for the state or on the bench, correct?
Correct.
Okay. So as somebody coming to the court with that background, how do you see your role as Chief Justice in looking at the cost of litigation in the state and the burden that's placed on the bar and on private litigants in the system, and any preliminary thoughts you have on ways to sort of improve upon our overall system of justice?
Sure. As I mentioned earlier in my opening, I want to have clear lines of communication with the bar and solicit their perspectives. I don't think I'm biased because I'm me, but I don't think that having been at the Attorney General's office and State's Attorney's office means that I'm unable to understand some of the pressures that are facing private litigants and private practice. I've been a judge for a while now, so I've had private litigants in front of me frequently throughout the last 12 years. And I appreciate that there are certain demands for the private bar that don't necessarily exist for public attorneys. I appreciate those demands, and as I approach all cases, I try to understand the circumstances and be fair and impartial.
I appreciate that. And, I guess no question on this, but we did also have the opportunity to discuss something that's near and dear to my heart, which is training of young lawyers. And I think as we've seen more and more things go remote, and less cases being tried across the system, I think we're doing a disservice to young lawyers, and the next generation of folks who are going to be those advocates in court, whether it's in the family law setting or somebody representing a person charged with a crime, or even in the civil litigation context. And so I appreciate our conversation on that last week, and I know you share, I think, many of my concerns about how do we encourage better training. And I think the branch has to play a role in that. I think the branch has to encourage more and more, not just law firms, but in-state service as well, younger lawyers having an opportunity to actually get on the feet and argue motions and take testimony. And that's the only way people learn, and it's the only way you're gonna develop that next generation of folks who can represent clients. So please keep that in mind as you move forward. And let's go back to dispositive motions being argued in the courthouse, please. All right. Further questions or comments? If not, we thank you for your time this morning. Congratulate you on your nomination. And we've got a couple members of the public sign up to testify, so we'll excuse you from the table.
All right. Thank you. And thank you all for your time.
First up will be Corey Betts.
Good morning. Thanks for having me here. For those of you who may not know me, my name is Corey Betts. I'm president of the Greater Hartford branch of the NAACP, and I am also chair of the Criminal Justice for the State Conference of the NAACP. I appreciate the opportunity to speak before you today and to offer my strong support for the nomination of the Honorable Raheem L. Mullins as Chief Justice of the Connecticut Supreme Court. Justice Mullins is a man of integrity, vision, and deep understanding of the law's impact on people's lives. In the years that I have followed his career, what has stood out to me most is not just his sharp legal mind, but his genuine commitment to fairness and equality. He understands that the law is not an abstract concept, but something that shapes the reality for everyday people in our communities. Especially for those who have often been overlooked by the system. We've come to a time in Connecticut history where having a Chief Justice who embodies both legal brilliance and compassion is essential. Justice Mullins brings both. His experience has been defined by thoughtful, principled decision-making and a strong sense of responsibility to ensure that justice is not only delivered, but felt by everyone. As someone who advocates daily for those whose voices are often silenced or ignored, I know that leadership like his can make all the difference. He has the character, wisdom, and moral clarity needed to guide Connecticut judicial branch through the complexities we face as a state. Justice Mullins' appointment would not just be historic, it would be transformational. His leadership would set a new standard for fairness, integrity, a commitment to justice for all. I strongly encourage you to confirm his nomination, and I look forward to seeing the positive change he will bring to our state's highest court. Thank you.
Thank you, sir. Questions or comments? Seeing none, appreciate you being with us. Scott Estel.
I'll be reading Mr. Asdell's letter.
All right, go for it.
Let me get the letter. I'm sorry about that. Now, unfortunately, Mr. Esdell could not be here, but he felt it to be very important that his letter was read on record. As you know, President Esdell was not just the president of the state conference, he is also chair of criminal justice for the national convention, and he is also a national board of the NAACP. So he said, make sure you read my letter. So I said, okay. So he says, dear members of the Judiciary Committee, I am writing to express my enthusiastic support for the nomination of the Honorable Raheem L. Mullins as the next Chief Justice of the Connecticut State Supreme Court. Justice Mullins' nomination is a historic moment for the state of Connecticut and the African American community. And I believe he is exceptionally qualified to serve in this role. As a member of the community, I have witnessed firsthand Justice Mullins' dedication to justice, fairness, and upholding the rule of law. His experience and commitment to diversity and representation within the judicial system make him a highly qualified candidate for the position of Chief Justice. I have no doubt that Justice Mullins will continue to uphold the principles of fairness, equality, and justice for all in our state's judicial system. He says, I am confident that Justice Mullins' leadership will bring about positive change and progress within the Connecticut judicial branch. His nomination is a testament to the progress we have made as a society and the importance of diversity in our legal system. And this is what he says. He says, I urge you to confirm Justice Mullins as the next Chief Justice of Connecticut State Supreme Court. His appointment will not only be a victory for African American community, but for all of the residents of Connecticut who believe in justice and equality for all. He says, thanks for considering my testimony and in support of Justice Mullins' nominations. I look forward to seeing him sworn in as the next Chief Justice of the Connecticut State Supreme Court. Thank you.
Great, thank you. Vasu Apiriman?
Yes. Thank you, Chair Winfield, Chair Staffstrom, and distinguished members of the committee. My name is Vasu Abhiraman, and I am the Rosenthal Building the Bench Director at Alliance for Justice, a national association representing over 140 public interest and civil rights organizations. Since 1979, AFJ has advocated for a judiciary that upholds equal justice under law. We congratulate Justice Mullins on his nomination for Chief Justice. His qualifications and experience on the highest court speak for themselves, and his elevation would continue a tradition of diverse representation in the leadership of this state's highest court. But while we celebrate the significance of this nomination, we must also recognize the profound opportunity that lies ahead. The vacancy Justice Mullins' elevation leaves behind is not just an empty chair. It's an opportunity to enhance the Connecticut Supreme Court by bringing in a justice with a uniquely diverse demographic and professional background. Justice Ketanji Brown Jackson's formal investiture to the U.S. Supreme Court was exactly 2 years ago today. And since she made history by becoming the first Black woman on the nation's highest court, states across this country followed suit in ensuring for the first time that Black women were represented on their highest courts. Michigan did it. Nevada did it. Illinois did it. But Connecticut has yet to see a Black woman serve on its Supreme Court. And it wasn't just Justice Jackson's race or gender that made history, it was a perspective she brought with her as a former public defender. That kind of experience is invaluable. It brings a voice to the court that understands what it means to represent the marginalized, to fight for fairness in the interest of individual citizens looking to have their rights affirmed. Connecticut can take a similar step forward. This vacancy presents a unique opportunity to nominate and confirm a professionally diverse woman of color, someone with experience defending the rights of the underrepresented or working in civil rights or employment discrimination, someone who has directly represented individuals in Connecticut and advocated for those who don't always have a seat at the table. So as you confirm Justice Mullins, I urge you to work with Governor Lamont to ensure that his associate justice vacancy is filled by someone who will truly broaden this court's perspective with historic demographic and professional background. Thank you. I look forward to seeing Governor Lamont and this committee seize this historic opportunity. And I yield for any questions.
Thank you. Seeing no questions, we appreciate you being with us. That will close our public hearing. And with that, I'd like to convene the Judiciary Committee meeting for Monday, September 30th, 2024. And we're going to stand at ease for one moment. All right, I'd like to call back to order the committee meeting. Seeing no remarks by my co-chair, Mr. Clerk, I will entertain a motion to, I guess it's not favorable report. It's a motion to confirm because we're in interim session. So it's reporting on, but it's not going to the floor. So, but it's still going to be all right. So it's in. We will entertain a motion to favorably report on the governor's nomination of the Honorable Raheem L. Mullins of Farmington to be the Chief Justice of the Supreme Court and a judge of the Superior Court.
So moved.
Second.
Motion by Representative Fishbein, second by Senator Winfield. Is there discussion on the nomination? Is there discussion? Seeing none, Mr. Clerk, please. Old habits die hard, my friend. Mr. Clerk, please call the roll.
This is a roll call vote to favorably report the nomination of Raheem L. Mullins of Farmington to be the Chief Justice of the Supreme Court and Judge of the Superior Court, Winfield.
Senator Winfield, any affirmative?
Staffstrom.
Staffstrom, yes.
Flexer.
Senator Flexer votes yes.
Quinn.
Representative Quinn votes yes.
Kissel. Fishbein. Blumenthal.
Blumenthal votes yes.
Callahan.
Callahan, yes.
Conley.
Representative Conley votes yes.
Curry.
Representative Curry votes yes.
Delaney.
Delaney votes yes.
Dillon.
Dillon votes yes.
Doucette. Dubitsky.
Dubitsky, yes.
Elliott. Gaston, Gilchrist,
Gilchrist votes yes.
Godfrey,
Representative Godfrey votes yes.
Hall,
Hall votes yes.
Harding, Hayes, Howard,
Howard, yes.
Johnson,
Representative Johnson votes yes.
Khan, Labriola.
Labriola votes yes.
Thank you. Lesser,
Lester, yes.
Marr,
Senator Marr votes yes.
Miller, O'Day,
O'Day votes yes.
Osborne,
Osborne votes yes.
Pavlik D'Amato, Porter,
Representative Porter votes a resounding yes.
Sampson,
Sampson is no.
Sims,
Representative Sims votes yes.
Veach,
Representative Veach votes yes.
Walker, Wilson,
Wilson is a yes.
All right, we will hold the vote open then until 1 o'clock. So we will stand in recess until 1 o'clock. I don't know that this committee will be back together again before the elections. So for those of you who are running again, good luck in your races. Get back out there and go knock some doors. Have a good day, everybody.
Tanner Miller. Hang on 1 second.
Are you talking to me?
Yes.
All right, what did you say?
Uh, how would you like to vote on the nomination?
In the affirmative.
Sweet.
Thank
You're all
you.
set. Thank you.
Yes, Senator.
Hi, how are you doing?
I'm doing well. How would you like to vote?
I want to vote in alignment with the chairs, so I believe that's in the affirmative.
Yes, sir. You are all set. I appreciate it.
Thank you so much. All right, bye-bye.
Bye-bye.
Yo.
Wait 1 second. Representative, how would you like to
Yes.
vote?
I'd like to cast my vote in favor.
All right, you're all set.
Thank you.
You got it.
Hi, Nate. You
Hey.
there?
Yeah, can you hear me?
Yes.
How would you like to vote on the nomination?
Rep. Giuseppe votes yes.
Awesome. Thanks. You're all set.
Thanks, sir.
You got it.
Hi. I just saw you there before, sorry, and I wasn't sure, so I went and asked.
No, you're okay.
Pavlik Demoto votes in the affirmative.
Great. You're all set. Of
Thank you.
course.
Bye.